Hi, this is Rick Park, and I'm with Mallorie Urban. And today we're going to be talking about a Supreme Court case in Washington.
It is Blanco v. Sandoval.
So this looks like it was a 2021 Washington Supreme Court case, and it's a dog bite case. What happens is there's a visitor that comes by pretty often. I think she's a Jehovah's Witness, and she's going to the tenant's house to do some praying, and she's been there 4 or 5 times before. And each time she goes there, the tenant, who has a pit bull, is barking aggressively behind a fence. But they end up talking outside of the house, and presumably they're praying outside of the house as well. And this last time that she comes, the 5th time that she comes over to the house, the pit bull either goes through the fence or jumps over the fence. We don't know exactly. There's 2 differing accounts of it, and bites the gal's ear. And it must
Yeah.
have been a pretty severe injury. Otherwise, we wouldn't see it here in the Supreme Court. It probably would have settled out. The gal, her name was Blanco, right? She sues the tenant who owns the dog, but she also sues the landlord who has nothing to do with the dog. The landlord does not possess the property, because as soon as the landlord leases it out to the tenant, then they give up possession of the property, and they also give up control of the property. So they really have no rights during the tenancy to actually be on that property, control it, possess it, or anything else. And in addition to that, the landlord also doesn't have anything to do with the training of the dog, whether or not the dog is dangerous or not. The security around the dog doesn't have anything to do. Although the tenant did ask the landlord whether or not they could build a fence, and the landlord said yes.
So Blanco here tries to make the argument that the landlord does have some kind of control or possession because of the rules, right? They have the ability to permit or not permit the dog to be there, and they got permission from the landlord to build the fence to contain the dog. And so therefore she's saying, oh, well, she was arguing that the landlord should be held responsible for the dog's behavior because of those things.
Yeah.
Which the court shuts down pretty quickly.
Yeah, doesn't like that argument. But so Blanco and Blanco's attorney, the person who's injured, they should be suing the tenant because the tenant owns the dog. And in Washington, there's strict liability around a dog owner who has a dog who ends up injuring another human. That's strict liability. It doesn't matter if there was negligence or not. It's just strict liability. But why
I don't know the background of the case here, but we can imagine that something else is going on with that claim, right? Like maybe Sandoval doesn't have insurance to pay, or for some reason, or maybe they did settle that part of the claim elsewhere. The court in this case is only looking at the landlord liability on a premises liability theory. So it's not looking at strict liability for the dog bite.
Correct. Or they're just looking at the dog bite, but against the landlord. So in any case, Blanco ends up suing the tenant, as they should, but then they also include the landlord. It doesn't seem like the landlord has any word that used often in the law is called culpability, which explain what culpability means.
Well, it's similar to liability or basically any blame for what behavior of the dog, right? So it's clear that the dog caused harm, and obviously under a strict liability has a right to be compensated for injuries. But they are arguing that there's also a negligence theory here, that the dog owner was negligent and some kind of liability, right? Culpability, blame to be had for the landlord because of their ownership of the fact that they had some level of control over whether the dog was there.
Yeah. And that doesn't seem right. So Blanco ends up taking both the tenant who owns the dog and the landlord into court, files a suit against both of them, and landlords a summary judgment motion. Can you explain what a summary judgment motion is?
Yeah, so a summary judgment motion is for the court to dismiss the case based on the fact that there's no legal grounds, assuming that all of the facts are viewed in the favorable to the party, which in this case is the landlord. That can be a little bit confusing, right? So just to show a clear example of this, did the dog jump over the fence or did the dog go through a hole in the fence? That's a dispute in the facts. So there's a question of fact to be had for the jury to decide there, right? If this were to go to trial. So basically what the summary judgment motion is saying is there might be some disputes as to the facts here, but assuming that the facts look good for the defendant, no case against us and you need to dismiss this case completely, right? Assuming that any of these facts could go either way.
So if you view the facts in the light most favorable to the non-moving party, and then you apply the law, if it's such that when the law is applied to facts that are most favorable to the person who's not making the motion, law is that the case should still be dismissed, then the judge will grant a summary judgment motion. They'll say, we don't even need to go to court on this because the jury is, they decide what the facts are, but we'll just presume the facts are in your favor and you still lose. So let's
Right.
not waste our time. We're going to dismiss the case. And that's what happened in this case, is that a summary judgment was brought saying, hey, even assuming all the facts are true that you're alleging, you still can't get liability against me because I didn't do anything. I didn't possess the
Right.
land. I didn't have control over the land. I didn't own the dog. I didn't know anything about the dog. I didn't build a fence. I didn't do any of the security measures. So why am I getting sued?
Right.
But so why is this case even up in the Supreme Court if that's the case? It seems like a pretty easy decision.
Yeah, so it sounds like the trial court agreed with the landlord, said you don't have any culpability here, and dismissed the case. The plaintiff, Blanco, then appealed that. And this case didn't even make it to the Court of Appeals. The Supreme Court of Washington decided we need to review this case. And so they decided to review it specifically on the question of whether the landlord has a duty to the plaintiff here, Blanco. And I think once you read through the opinion, you realize that Blanco is making an argument trying to analogize this case to another case called Oliver. And that case is sort of an outlier. It's a Court of Appeals case in Washington that's basically found that there is potentially a premise liability claim that you could bring against a landlord in this kind of situation. And I think the Supreme Court of Washington seemed like they wanted to really shut that down because they've made it clear in other cases that this is not something they want to be possible, that landlords should not be held liable for their tenants' legally owned animals, dangerous or not. And that's been made clear in other cases. But there's a little bit of a dispute in the Court of Appeals because there's this Oliver case in the Court of Appeals that seems to be saying something a little different. And so it seems like they wanted to give us some clarity on that. Because the Supreme Court doesn't just take any case. They take a case when there's a dispute in the Court of Appeals or a national, disparity in how these standards are treated. And they want to clarify how they want the law to be interpreted here in Washington. And it seems like that's what's happening because they also, in this opinion, cite a couple of cases in California that seem to say landlords could have some liability in this kind of situation. And they're distinguishing this case from those saying, we actually don't agree with what California is doing. We don't want that here. We don't want
Yeah, and
landlords to be held liable in those cases.
Washington follows California all the time. So they're probably making a public policy statement as well, saying, hey, on this issue, we're not following California. Let's make that clear and let's do it
Yeah.
quickly. Yeah.
And it seems to me like the plaintiff attorney here, Blanco's attorney, wanted to try to use Oliver to maybe make some more precedent towards the side of maybe we could bring these kinds of claims against landlords. And this didn't even make it to the Court of Appeals, which makes me think the Supreme Court wanted to prevent that from getting muddied even further in the Court of Appeals by saying, no, this is clear in our law, case law, in our precedent. We don't want this to be possible in Washington.
Yeah, and I haven't looked at the background of the case, but there may be some other reasons why there should be a policy to make the landlord responsible as well, kind of secondarily. I'm just thinking from the plaintiff's perspective. So here's this gal who has a pretty bad injury, gets bitten by a pit bull on her ear. I don't know the extent of the injuries, but let's say it's pretty bad. Well, if she tries to sue the tenant and the tenant doesn't have insurance, like you were saying early on, then where do I get any compensation for getting my ear bit off if that was the case?
Yeah,
There should be some compensation. And maybe, like in California or other places around the nation, they put it on the landlord's responsibility to ensure that the tenant has some sort of tenant insurance. So
right,
renter's insurance or some sort of insurance that may cover, because if it was a property owner, that not a tenant, that property owner most definitely would have insurance. I mean, mortgage companies require insurance on the property.
right.
So at least to make or force landlords to require their tenants to have insurance, that may be one possible reason. And another possible scenario that I was thinking of is maybe the insurance company was like, okay, well, we'll insure you, but we're not going to insure a pit bull. Because
Mm,
so they
right.
can carve out particular breeds of animal. If they're like, okay, those are too risky, I don't want to pay out on those, I'm not going to insure you on that. Yeah.
Right. Yeah, so you can see how there's policy arguments that would make it makes sense, right, that other jurisdictions are doing something different and that the Supreme Court would want to clarify that because there's arguments on both sides. And we can see later in the opinion that here at the bottom of page 10 that the court really digs in on the sort of opposing argument to that, which is the way they say it is this rule promotes the salutary policy of placing responsibility where it belongs rather than fostering a search for a defendant whose affluence is more apparent than his culpability. So that phrasing might be a little confusing, but basically what they're saying is we don't want people going after landlords just because they might have more money, they might have bigger pockets when they're not really culpable. And this is a good example of a case where that makes sense in your brain, right? Because if you look at this case on its face, I think common sense, most people would not say, oh yeah, the landlord's responsible. They weren't even anywhere near this dog you were saying. And so this is a very clear cut instance of they had no interactions with the dog. There was no evidence that the dog was dangerous. The landlord had no reason to be on notice that the dog might have been dangerous. There's nothing here that would give us, just as humans, an indication that we should hold this person liable other than they have bigger pockets.
Yeah. No, and that's a huge deal. I mean, there's a concept in the law here in Washington called joint and several liability, which means even if you find that the landlord was 1% liable, if it's joint and several liability, they have to pay for all the damages the other party can't pay, which is maybe why the plaintiff in this case went really hard and all the way down the line for this case, is because there was a lot at stake.
Yeah. And you can see where this might get a little bit gray, right? In this case, when we describe the facts, the landlord had no interaction with the dog, was not asserting any level of control or power over the dog other than permitting the dog to be there. The fence, they gave permission for the fence to be built, but didn't do any inspection of the fence. And there was no reason, if they were to inspect the fence, that there would have been a problem because the dog had never showed any signs of aggression before or trying to escape. So, but you could imagine a case where the landlord does assert a little bit more control over the situation, where this might be a little bit more gray. And we might think, oh, maybe the landlord is somewhat liable here. But I think the Supreme Court here is really trying to sort of make that not possible. I think at the top of page 6, I was looking back at this and found that made it pretty clear. They talk about this case Frobig, which is the sort of analogous case that the defense really highlights as a case that is similar to this one that they've already decided. Frobig was a case very similar to this, where as someone was injured by someone else's animal, but in that case, the animal was a Bengal tiger. So it was much more obvious that that animal would be dangerous. The landlord maybe was more on notice that there was a dangerous animal that could have hurt somebody, right? But in that case, they also found that even if the landlord knows of the danger and has some level of control over the animal, even then, we don't want them to be held liable. It is the tenant's responsibility to make that person whole.
Yeah, they made it very clear in Frobig, and that's legal precedent. So, once you make a decision like that in a case, every trial court should rely on that case if the facts are similar. And really that's what lawyers do is they find a case that's similar and they say the case that I'm working on for my client right now it's just like Frobig. It's almost the same exact case. You could just switch out the Bengal for the pit bull and it's the exact same case. And
Right.
what the other side lawyer is trying to do is saying that's nothing like our case. A Bengal and a pit bull? Come on, those are 2 totally different animals. It's not the same case. So,
Right.
they will find another case and say, "Well, this other case has similar facts to ours here, and that's why you should rule in a similar fashion to this particular case." So, finding legal precedent is very important. That's part of the research part of lawyers, that finding good cases and then being able to articulate why your case is very similar to this and why your case is totally different than the one the defense is presenting. That's the skill of a lawyer.
Yeah, absolutely.
Yeah, and so in this case, can we see who all concurred? Were there any dissenters?
Sense to me. If you, I mean, just from what you were saying too about the analogous cases and trying to distinguish cases, I mean, this page 6, it makes it pretty clear, they're talking about Frobig at the top. They really, I mean, once, and with precedent, this doesn't just bind trial courts and courts of appeal, but also the Supreme Court, once it's made a precedent, has to have some really good reason to change it if they're going to change it. And so they look at this Frobig and they say, this is exactly the same case, just a different animal, right? And when you look at the case that Blanco's lawyer chose to try to analogize, the facts are quite different from this case. So it was sort of a shot in the dark, in my opinion, to try to rely on this case as precedent
Yeah,
to create
which
this.
but that brings to light another reason as to how this case got to be a Supreme Court case, because they can only take a certain amount of cases a year, so they can't take every single case that somebody disagrees with. They handpick those cases because they only have a couple, and if it's such a long shot, there was clearly Frobig was a very analogous case, almost exactly the same, and then the other side's attorney brought a case that wasn't even really close. So you would think, how did it end up in the Supreme Court if it wasn't a close call?
Yeah, and
It,
I don't know all the
yeah,
background here, but it seems to me like the Supreme Court was a little to allow the Court of Appeals to try to extend this Oliver case any further. They actually, in their legal jargon kind of way, made it pretty clear that they disagreed with the holdings in at the bottom of page 6 here. They said that the factual basis for analyzing the claim under premises liability theory is far from clear.
yeah,
In the opinion on Oliver. So they clearly don't really agree with that Court of Appeals decision. I think they didn't want to allow the Court of Appeals to potentially muddy this rule that's been established in Frobig any further.
yeah. So they just
Yeah.
wanted to clear up everything and say, hey, Frobig is controlling. It's the legal precedent that we want to follow. We do not want to follow California or some of the other jurisdictions around the nation who do allow for liability against the landlord, even when the landlord has relinquished control and possession over the property and is not a dog owner. So I think Washington did a good job here by making it clear, number one. And number two, I think the policy is good too. Like that would discourage landlords from having tenants who have animals if they were somehow
Right.
going to be liable. I mean, it would
Which
encourage landlords to make sure tenants get insurance, though, and insurance coverage that's sufficient. So,
right.
I mean, I guess it does have some
There's
some good policy reasons to allow it, but
but you think I mean when you
overall,
think about the sort of implications of what happens with the opposite rule, if landlords just are starting to discourage people from having animals, then it makes it harder for people who have animals to find homes and housing, right? So I do think that this lands correctly on the policy side of things also.
Yeah, I agree. And what do you think about pit bulls in general? I mean, prior to the podcast, you and I were talking, I was telling you, one of my best friends, had a pit bull for a decade and loved that dog to death. One of the top three favorite things on this earth. So not just people, but out of anything, people love their pit bulls, and they'll argue to the end that pit bulls are great dogs. What are your thoughts on that?
Yeah, I think in general, different dogs have different temperaments, right? And so there are people who would argue that pit bulls have a different temperament that makes them more likely to be aggressive. I think, though, that it's more about, I think in general, dogs require a certain level of training and understanding of their behavior, depending on the breed, of course. And I think certain breeds, it's a little bit more dangerous to not understand that behavior. And we were talking about how pit bulls uh, are they have a strong jaw, they have a strong body. So, even if a less trained dog who's a little bit smaller and not as strong of a jaw, if they bite someone, it's not going to be do nearly as much damage as a pit bull. And so it's a little bit more dangerous to not have a well-trained pit bull than it is to not have a well-trained chihuahua, you know?
Yeah. Well, and I've been in this business now for like 26 years, and it just so happens that, if I've seen 100 dog bite claims, I'd say about 50 of them were pit bulls. And
And that's not surprising.
yeah, I mean, those numbers are staggering. It's not coincidental. I mean, there's something to that. And I can't just think that pit bull owners are incompetent. That doesn't make sense to me. I get some of them don't train their dogs as well as they should.
Yeah, I don't know a ton about the background of how they were bred, but I do know that I think that they have the potential to be aggressive. I think a lot of dogs have the potential to be aggressive. I think, yeah, it could have something to do with the reasons for why they were bred, or the way that people keep them, or yeah,
Or
something
a
about
combination.
their
Yeah.
temperament. Yeah, I think it's probably a combination of all those things. Yeah.
Yeah. Okay. Well, I think this was a great little lesson. We're going to do this hopefully once a month and pick another case. So if anybody wants to hear about a case or see us analyze a case, put a comment below, and we'll see you next week. Thanks,
Great.
Mallory.